Under human rights legislation, employers are required to reasonably accommodate their employees' physical and mental disabilities. To tell us more about this legislation, we've reached Kristen Alani, a senior associate with Getz Collins and Associates this morning. Good morning, Kristen.
Good morning. How are you doing today?
Doing great. And of course, we're talking about the employer duty to inquire. Can you explain what this is and what happens if an employee doesn't directly disclose their need for accommodation to their employer?
Absolutely. So, generally, the employee does have the obligation to disclose if they require some kind of accommodation and then to provide relevant disability-related information to their employer. If an employee is having problems performing their job duties because of a disability, they really should inform their employer that they are having those issues because of something medically going on. They don't have to disclose the exact disability. And then they'll usually have to provide some medical documentation. But there's also a situation where an employer might suspect that a medical condition is involved, but the employee hasn't actually told them. And that's kind of where this concept comes in.
Okay, so when does a duty to inquire arise, and what if there is a complaint about something that occurred at a workplace event?
So if a duty to inquire arises, then what a duty to inquire is, to define it, is when an employer knew or perceived or reasonably ought to have known or perceived a link between the employee's performance, so there's some performance issues going on, and a mental or a physical disability. So this might come up where there's an alteration in the employee's past mood or behavior, or maybe even their specific performance that's material enough or that has continued on for long enough that the employer suspects or should suspect that a health issue is involved. In one decision, so to give an example from the Alberta Human Rights Tribunal, the employee mentioned to his supervisor that he thought he had a mental health condition and that he would make a doctor's appointment to find out more about it. And that was held to be enough to trigger that duty to inquire before the employer then went ahead and terminated that employee as a result of performance-related issues. And the employer had to pay $20,000 in general damages as a result of that.
Wow. Okay, so what should an employer do if they suspect that there may be a link between an employee's performance and a mental or physical disability?
So the most important part is to provide the employee with a meaningful opportunity to identify what they are dealing with or to request some kind of assistance or accommodation. So the issue should be raised in the context of work performance, perhaps the employer indicating what they've noticed in terms of the performance, and then specifically outlining kind of the behaviors that have resulted in the request for more information from the employee. If that employee does disclose a need for help or accommodation, the next step would be to request supporting medical documentation from that employee. It's important to ensure as an employer that you're aware of all the medical restrictions or requirements that might be at play, and a medical professional might provide accommodations beyond what an employee themselves might see as necessary or required.
Yeah, really interesting and important information for the workplace. Thanks so much for this, Kristen.
Thank you.
If you want more information, be sure to head on over to GetzCollins.com.
Sponsored by Getz Collins and Associates, attorneys with modern ideas and old world values.